the firearms industry is the only industry that can't be sued.
We're the Arms Attorneys. Today we're talking about a recent lawsuit filed against Smith Wesson because a mass shooter used one of their firearms. Stay tuned. We're going to talk about what's in the lawsuit and what we think is going to happen based on precedent that has been recently set and why it's really, really bad news for all of our ability to buy a firearm in the coming decades. But before we get started, show your support for the Second Amendment by hitting the like button. And really what we're talking about here is starts in tragedy. So we should say that. I mean, we don't want to minimize anyone's pain when they and their families have been the victim of a mass shooting. It's awful. We're talking about the Highland Park shooting in Chicago over this past 4th of July, 2022. Right, Richard?
Yes, well, this is an immense tragedy, and as you can expect, the families are looking to make themselves whole. Unfortunately, for every wrong, there isn't a right, but that's kind of where we find ourselves under these circumstances. Now, we have kind of three different claims that we're going to go through here. The first is against Smith & Wesson, the firearms manufacturer and one of the firearms that was allegedly used in the incident, against the gun shop itself and how they related or maybe helped facilitate, according to these plaintiffs, this shooting. And finally, the shooter, obviously, and his family and what part they played in causing this tragedy. Now, so there's kind of three claims that we have floating around here, and we'll have the lawsuit popped up on screen so you can see the parties involved. But really, to start things off, we have to talk about the Protection of Lawful Commerce of Arms Act.
Yes, and this actually is weirdly just one of the things that I really, really enjoy talking about. It's an interesting law. So passed in 2005, the Protection of Lawful Commerce and Arms Act essentially is meant to protect gun manufacturers from being sued for their products doing exactly what their products were intended to do. And it's this idea, and it's an idea that we've had in tort law for as long as there's been tort law, right? Which is that someone's intervening or superseding criminal conduct doesn't, it cuts the line, right? It cuts the liability line. And so then let's say, for example, I give Richard my gun and Richard does something negligent, like let's say he leaves it in his front lawn, right? Like puts it down in his front lawn, and that's Richard's negligence, right? But if a criminal then takes that gun and robs a bank with it, Richard isn't going to be liable to the people at the bank because Richard's negligence, yes, exists, but is cut off by that criminal's superseding or intervening conduct. And so we have this idea with guns, right? The gun functions the way it is intended to. The people who manufactured it aren't responsible for a criminal's act with it. Unless, right, it doesn't mean that a manufacturer is never responsible. If their product malfunctions, if there's a contractual dispute, they can still be sued, can still be held liable. But if Smith & Wesson manufactures a firearm and that firearm works as intended, but a criminal element uses it to commit a crime or to hurt someone, that is not Smith & Wesson's problem, except, right, there's an exception to this law, which is just a bizarre exception if you ask me, but it's an exception to the manufacturer marketing the product in a way that violates state or federal law. And this is what's being alleged here, is not that Smith & Wesson just sold a gun that was used, but Smith & Wesson illegally marketed the gun that was then, of course, used in this tragedy. And what's their beef with the marketing?
Yeah, so, and this is the primary claim against Smith & Wesson. They marketed the firearm in such a way that it would make its way to the hands of disturbed young men. That's what they're saying.
Military-esque marketing.
Right.
Yeah. It's the claims are, to me, they're very nebulous and sort of vague, but I don't know, maybe you have a different take on it.
No, but it's, you think about this in any other context, Ford or some other car manufacturer getting sued for the acts of a drunk driver. Obviously there's a tragedy there and there's a want to, make things whole again. It wouldn't make sense logically to put Ford on the hook for, the acts of an intoxicated driver. And so, that's what the idea behind the Protection and Lawful Commerce of Arms Act is. To stop frivolous lawsuits. And we've heard, you'll hear pundits and you'll hear these sound bites, even from Joe Biden say, the firearms industry is the only industry that can't be sued. Well, that's simply not true. There are big carve-outs for fraud, just like Emily covered, for fraud, for manufacturers' defects, for the marketing, for the illegal marketing. And so That's not necessarily true, but this doesn't seem to fall into that category, based on my review.
No, and I like your car example because imagine a muscle car, right? Something that is marketed for going fast. Personally, I love muscle cars. I love to drive fast. But if someone takes that muscle car, which is marketed in a very specific way, and drives really, really, really fast and ends up killing someone or hurting someone, is that Ford's fault? Is that Dodge's fault? No, under no circumstances, right? Even though, yes, it's marketed as a fast car. Same deal here. And they're marketing it allegedly as, it's like a military style and in a way that's very intriguing to disturbed young people, says the lawsuit. But marketing does not make the criminal act. And so you would think to yourself, can they really get away with this? And the answer is maybe, right? Because we had a very similar issue in February of this same year, actually, 2022, in which Remington settled their lawsuit with the Sandy Hook victims' families. Now, a settlement does not legal precedent make. However, it settled nonetheless. It was something like $73 million.
Right.
And I think if you're really looking at it, because I'm not sure the case would have not ultimately played out in Remington's favor, but the optics, I think, are not great when these manufacturers look at fighting the families of victims. And perhaps the settlement is a cost of doing business. But the thing is, if all these companies start building in, we have to pay out all these huge settlements when our firearms are used as firearms, but just by a horrible person, our firearms are about to get way, way, way more expensive, maybe unreachably expensive.
Yeah. And I mean, crystal ball time. I mean, if this lawsuit is a signal to anything, I mean, we'll likely see Daniel defense sued arising out of the Uvalde tragedy. I mean, and this is not going to stop. And so there's a reason why the Protection and Lawful Commerce of Arms Act exists. The other two parts of the lawsuit, they're suing the shooter himself. That makes sense. Suing the father of the shooter for his sponsorship of the FOID card, his firearm owner's identification card. The third part of the lawsuit is the gun store itself. They allege, hey, this was an unlawful transfer because where the shooter lived, that firearm was not legal in that municipality, that city itself. And I don't necessarily think that would be on the gun shop.
Yeah, so we were talking about this earlier, and frankly, it's something that I would like to dig into a little bit more because as a Texas lawyer, we don't encounter this.
Yeah,
right?
We have statutory preemption, so the laws are uniform.
Yes, all guns that are legal in Texas are legal everywhere in Texas. Makes sense. Of course, Illinois, not so much, and they have a list of firearms that are banned. And so the allegation here, to my understanding, is the specific firearm that was purchased was legal at the address where it was sold, that gun store. However, not legal per the municipality or county, or I think municipality, that the purchaser lived in, as evidenced by his identification. Is that something that the gun store has to account for in the state of Illinois? And did they really screw up? I mean, I'll be honest, I don't know the answer. I would love to research that, but that is something that we just have not had time for quite yet.
Yeah, and I think it comes down to state of residence. I don't know that they could...
I don't know that there's any law that governs that either, but it's going to take a lot of work on my part, so I'll get there.
We already had that dangerous precedent set by the Remington case, and this seems to be a signal of things to come with future tragedies and future lawsuits. And does the PLCAA mean anything if it doesn't stop these, I mean, while it is a tragedy, and don't get me wrong when I say this, this is probably a frivolous lawsuit against the manufacturer.
I believe it to be, yes. Thank you for watching. If you appreciate this content and you want to help us help the 2A, consider becoming a channel member. We have more and more of you. We're really excited by the number of people who want to offer that level of support, and it's very much appreciated. Until next time, we're the Armed Attorneys.